My son-in-law called me too old to understand technology, while standing 6 feet from a man who had spent 36 years designing bank security systems. He was telling my daughter how easy it would be to put my house and investments under his authority. I stood outside my study holding a folder of property tax statements. Mason thought I had gone upstairs. The door remained open just far enough for his voice to reach the hallway. "Your father is old-fashioned," he said. "He does not understand digital forms. It would be easy to get him to sign a power of attorney." Laura lowered her voice. "What if he reads it?" That question hurt more than Mason's insult. My daughter did not ask why her husband wanted authority over my property. She asked whether I might notice him taking it. Mason laughed. "He still asks the bank to mail paper statements. He will not know what the document actually lets us do." The edge of the folder pressed into my palm. I relaxed my hand before the cardboard bent. The paper statements were not there because I feared computers. I requested them because 3 decades of securing financial systems had taught me that a screen shows the current version. "A separate record preserves how it got there," Mason continued. "Once I have authority, we refinance the house, move the investments into a managed account, and fix everything before he notices." Laura asked, "And if he does notice, by then the documents will say he approved it." On the shelf beside me sat a brass vault key in a walnut frame. It had never opened an actual vault. Commonwealth Trust Bank had presented it to me when I retired, and Evelyn had mounted it beneath a sentence written in her careful hand. "A lock is not distrust, it is care made visible." My late wife had understood something Mason never had. Security was not suspicion for its own sake. It was the work a person did before betrayal, so the truth would not depend on who sounded most convincing afterward. I stepped away from the study before Mason or Laura saw me. At dinner that evening, I asked Mason whether he could help me organize my financial documents on the computer. His expression changed before he could hide it. "Of course," he said. "That is what family is for." Laura looked down at her plate. I smiled. Mason believed I had given him access. What I had actually given myself was time to protect what he had no right to control. I was 73 and retired, but retirement had not erased my profession from my mind. As Chief Security Systems Architect at Commonwealth Trust, I designed rules that made one document insufficient to move another person's money. I did not chase criminals through glowing lines of code. I built the conditions that forced a convincing document to prove itself. New agents required independent verification. Address changes produced alerts. Digital records preserved who submitted a document and what requests followed it. Legal, branch, and fraud teams held separate authority because no secure system trusted one person to approve everything. Mason knew only that I had worked in bank technology. He imagined an older man maintaining servers. He could buy software, present dashboards, and speak confidently about automation, then mistake operating the tools for understanding the structure beneath them. I let him believe that too. Laura knew more. At 12, she had completed math homework in the bank cafeteria while I supervised a security migration. She had watched employees wait for my approval before restoring access, and Evelyn had explained my title to her. Years later, she reduced my career to working with bank computers. Mason mistook the shorter description for the whole truth. I could excuse his ignorance. Laura's silence outside my study was different. She knew enough to correct him and needed the money badly enough not to. Evelyn and I had lived carefully, not poorly. The paid-off house was worth approximately $1,250,000. My investments held about $1,700,000. With the cabin, cash reserves, and education funds, the estate approached $3,500,000. Mason saw unused capital. I saw the house where Evelyn had taught our daughter algebra at the kitchen table, the cabin where our grandchildren learned to swim, and enough independence to ensure that no one could choose my care according to what they hoped to inherit. Mason's company, Reed Property Intelligence, sold data tools to real estate investors. At conferences, he described ordinary reports as intelligence products. During the previous year, 2 investors withdrew, a lender demanded repayment, and a major client disputed a contract. 3 days before I overheard him, Mason admitted on a driveway call that his exposure approached $540,000. He needed a larger amount to preserve payroll, settle with investors, and keep his own house from foreclosure. My home had become the solution he could not place on a company balance sheet until I gave him authority. Laura knew how serious the debt had become. 2 months earlier, she had asked whether the cabin could support a temporary family loan. I offered to review Mason's books and help him negotiate with the lender. Mason never sent the records. He did not want help that required him to explain how the business had failed. He wanted an asset that required only my signature. The following Saturday, Mason arrived carrying a laptop and a portable scanner. Laura brought 2 empty document boxes. "We will start with consolidation," he said. "Most fraud happens because older people keep information scattered." He said older people while looking directly at me. "What would you need?" I asked. "Account statements, identification, property records, insurance, tax documents, signature pages. We can build one secure family archive." "Secure for whom?" He smiled as if I had asked where the power button was. "For you." Laura and I would only have emergency access. He opened a diagram showing my accounts flowing toward a box labeled Family Management. I asked whether the archive would change ownership of anything. "No, Victor. This is organization, not control." Then he asked whether my brokerage allowed an authorized agent. He asked whether the house still had a mortgage. He asked where I kept the deed, whether the cabin was titled separately, and which number the bank used for verification calls. No one needs that information to scan a tax return. Laura began sorting envelopes. When Mason asked for a copy of my driver's license, she said she already had a scan from a travel form we had completed the previous summer. I looked at her. "You kept it? It saves time," she said. Mason asked which telephone number Commonwealth Trust used for account recovery. Before I answered, Laura gave him the number I had maintained for years. Then he asked whether I still used the family security phrase Evelyn and I had chosen. "Why would a document archive need a bank security phrase?" I asked. "It would not," he said quickly. "I am mapping the full recovery process in case you lose access." Laura continued sorting papers without looking at me. She had begun answering questions I had not authorized Mason to ask. Convenience is the word people use when they want the removal of a safeguard to sound helpful. Sophie arrived halfway through the afternoon with a backpack from her first-year computer science program. My 19-year-old granddaughter found Mason's diagram on the table and frowned. "Grandpa does not need one giant archive," she said. "That creates one giant failure point." Mason dismissed her with a wave. "That is classroom thinking. Real systems prioritize usability." Sophie glanced at me. Months earlier, she had tried to install a budgeting application on my phone. I declined because it requested access to contacts and location data it did not need. She assumed I disliked applications. I never explained that I disliked permissions without a purpose. "Your grandfather asked for help," Mason said. "Then help him," Sophie replied. "Do not redesign his life." I sent her home before the disagreement grew. She knew nothing about the conversation I had overheard, and I intended to keep it that way. If I changed my estate plan, no one would be able to claim my grandchildren had frightened or flattered me into doing it. Mason scanned the property tax statements and several harmless insurance pages. I gave him no original identification, no brokerage credentials, and no signed authority. Before leaving, he placed a checklist beside my keyboard. "Next time, we should add account contacts and emergency permissions." "I will read it. It is standard language. Then it should survive being read." For the first time that afternoon, his smile tightened. They thought paper made me old-fashioned. Paper was how I noticed what they wanted me to sign. The next morning, I carried Mason's checklist and the framed brass key to Nadia Brooks, the elder law attorney Evelyn and I had used for our last estate review. Nadia read every line before she spoke. Then she turned the frame toward herself and read Evelyn's sentence. "Why did you bring this?" she asked. "To remember what the paperwork is supposed to protect." Nadia set the key beside Mason's checklist. "Then we protect your authority without creating authority for anyone else. No signature they can reinterpret. No money placed at risk. Has Mason given you a power of attorney?" "Not yet." "Have you signed anything electronically?" "Nothing." I told her what I had heard outside the study, including Laura's question and Mason's answer. Nadia did not call it a family misunderstanding. "They are discussing financial authority, identity documents, and a plan to create apparent consent," she said. "We prepare as though they may act." She checked my existing estate documents. Laura held a limited backup role in one older authorization. Mason held none. Nadia prepared written revocations and began replacing family control with an independent professional fiduciary. I did not disinherit anyone that morning. Anger was not going to make my estate decisions any more than greed would make theirs. I removed access first. Any consequences would come from what they chose to do. Not what I suspected. Nadia arranged an independent appointment with Dr. Helen Wu. The evaluation was not designed to prove I was cleverer than Mason. It documented that I understood my assets, the people who might benefit, the authority a financial power of attorney could grant, and the consequences of refusing one. Dr. Wu asked me to describe the house, investment accounts, cabin, and existing education funds without looking at notes. She asked who controlled them now, and who would gain authority if I signed what Mason proposed. I answered each question. I also told her that Sophie and her younger brother knew nothing about the conversation or my legal appointment. If my estate changed, it would not be because my grandchildren had campaigned for it. Dr. Wu asked why I preferred mailed statements. "Because I compare them with the online account history," I said. "Two records created through different channels are harder to alter in the same way." She asked whether using paper meant I could not manage digital accounts. "Preference is not incapacity," she said into her recorder. "Caution is not confusion." Her report confirmed that I understood my property and decisions and showed no cognitive impairment. When I returned home, Mason was waiting in the study with Laura. He had created folders on my computer and labeled them with the names of my bank, brokerage, house, and cabin. "I thought we agreed you would wait for me," I said. "I only built the structure," he replied. "You still control everything." He turned the laptop toward me and showed a list of documents he wanted scanned next: identification, contact authorization, account access, property management, durable financial power of attorney. The last item appeared between harmless forms exactly as I had expected. I pointed at it. "That one looks complicated." Mason softened his voice. "It only lets us help if the digital side becomes too much." Laura finally looked at me. "Dad, you do not have to prove you can manage everything alone." I heard concern in her voice. I also heard the permission she was giving herself. "Perhaps you are right," I said. Mason leaned back satisfied. That night, I passed the study and heard him tell Laura that I had finally admitted I could not manage the digital world. He believed the most difficult part was over. The next morning, I called Lena Rao, the woman responsible for protecting Commonwealth Trust from people exactly like him. Before Mason finished preparing the document he intended to use against me, Lena Rao placed 4 barriers between him and every dollar I owned. She did not do it because I had once been her supervisor. She did it because I reported a credible attempt to obtain financial authority through deception. Lena had joined Commonwealth Trust during the final decade of my career. She now directed the bank's fraud prevention division, which meant she held authority I no longer possessed. Retirement had not left me a secret switch inside the system. It had left me with the knowledge to call the right person before money moved. Lena met me in a glass conference room at the bank. She checked my identification against the record and had another employee witness the meeting. She did not wave me past a control because of my name. That would have violated everything we had both spent our careers protecting. Only after the verification was complete did she turn over a blank legal pad. "No conclusions," she said. "Give me the sequence." That had been one of my own rules years earlier. A security officer who began with a villain often found only the evidence that fit him. A security officer who began with events could still be surprised by the truth. "Start with exactly what you heard," she said. I repeated Mason's plan, Laura's question, and the list of information they had already requested. I told her I had signed nothing and granted no new authority. "Has either of them submitted a document?" "Not yet." "Then this is prevention, not recovery." Lena placed enhanced verification on any new power of attorney, address change, or agent request. Each would require legal review, a callback through the number already on file, verification of the notary, and a new security phrase created in person without any family reference. If anyone says you are unavailable, confused, or too ill to speak, the request stops, she said. It does not become more urgent. Mason had already begun treating my age as permission to speak for me. "The system will not reject Mason because I know you," she said. "It will verify his document the same way it should verify every document." That distinction mattered. A secure system could not depend on whether the victim happened to know the fraud director. Nadia activated the remaining protections outside the bank. She placed a credit freeze with the reporting agencies, registered a deed alert on the house and cabin, and instructed my brokerage that no new agent or transfer could be approved without my in-person confirmation and her review. The safeguards did not accuse Mason of a crime he had not yet committed. They made sure his next choice could not become my financial loss. For the first time since I had overheard Mason from the hallway outside my study, I felt my shoulders loosen. I had not realized how much of my body had been waiting for a door to open without me. Now the doors were still mine. When I returned to Nadia's office, she gave me the standard family digital records training packet her firm used with clients organizing electronic records. It was not a power of attorney. It was not created for Mason. It contained security instructions, specimen forms, and an illustrated power of attorney page. Every authority page carried the same plain warning file. Not valid. No authority granted. Nothing in the packet carried a valid signature, witness certification, or notarization. Nadia's office kept its standard digital template as part of the client file. I took the guide home and left it beside the brass vault key on my desk. Evelyn's sentence did not tell me to punish my daughter. It reminded me that love and access were not the same thing. I could still hope Laura would stop without leaving my home, investments, or independence unprotected. At breakfast the next morning, I told Mason I wanted his help scanning insurance pages and tax records before we touched any real estate or brokerage documents. He arrived within an hour. He noticed Nadia's packet beneath the folder on my desk. "This is perfect," he said after reading the title. "Once you understand the workflow, the actual forms will feel simple." He flipped past the first warning. Then the second. His thumb stopped on the sample power of attorney. "Lawyers put disclaimers everywhere," he said. "Do they matter?" "For training, yes. For organization, not really." "That guide is not part of the archive," I said. "Put it back beneath Nadia's folder." He did. Then Mason scanned the insurance pages in my study and asked whether I wanted the files stored locally or in a shared online folder. "Locally," he sighed. "The cloud is safer than one aging computer." "Then make a local backup too. You always add extra steps." Extra to whom? He did not answer. He opened an optical recognition program and showed me how it could convert a scanned insurance page into editable text. "See?" he said. "If a name or date changes later, you do not have to scan the whole thing again." "Why would the name change?" His hand paused on the mouse. "I mean on a general form. not yours. He asked for a photograph of my driver's license so he could build a folder naming system. I told him to use the word identification as a placeholder. Then he asked whether I wanted to practice inserting a signature image. No, I said. A signature is not decoration. Mason smiled as if I had made a charmingly old-fashioned remark. In reality, I had designed authentication controls before he had opened his first email account. After Mason left, Nadia's packet was no longer beneath the folder. I had not given it to him. He had taken it with the document box. That afternoon, my printer produced a page Mason had not meant to leave behind. While working in my study, he had printed a calibration sheet from his laptop to confirm the connection. A second job had remained in the queue. After he left, the printer woke and delivered the final slide of a financing projection, Hale property liquidity, $650,000 available. My house appeared beside a proposed home equity loan. The next lines allocated money to a bridge lender, investor settlement, payroll, and business reserves. There was no reserve for Sophie or her younger brother. Mason had already presented my home as available capital before I had signed anything. I gave the page to Nadia and told her the client guide was missing. She recorded both facts without treating either as proof of forgery. We respond to what he does, she said, not what we fear he might do. Then she retained Caleb Monroe, a forensic accountant, to review Mason's public filings, creditor actions, and the financial material lawfully available to us. Caleb confirmed that Reed Property Intelligence was carrying approximately $540,000 in immediate obligations. Mason needed at least $650,000 to keep the company operating and prevent claims from reaching his personal assets. The number did not come from a private account Caleb had entered. It came from a creditor lawsuit, financing notices, a recorded business lien, and figures Mason himself had shown in the projection left on my printer. Caleb arranged the dates across Nadia's table. The earliest entry was nearly 4 months old. Mason had spent those months eating at my table, asking about Sophie's tuition, and telling me his company was preparing for expansion. He had not been preparing to expand. He had been preparing to reach my house. His recovery plan lists your home as available equity, Caleb said. The date is earlier than the packet and earlier than any claimed authority. So this was not an emergency, he discovered later. It was his plan before he asked you to sign. The page explained why Mason moved so quickly. It did not explain why Laura helped him. I learned that part the following evening. Laura came to my house alone and asked whether I still had the cabin deed from the year, Evelyn, and I transferred it into joint ownership. I said Nadia had the estate records. Mason only needs an old signature for the file index, she said. A file index does not need my signature. He is building a complete archive. Then he can archive the documents I gave him. Her face tightened. Dad, if the business collapses, we could lose our house. Then ask me for help, honestly. You offered to review everything. Mason cannot hand his company to you like a school assignment. Review is what people request when they want help. Authority is what they request when they do not want questions. She left without the deed. 10 minutes later, I heard her speaking to Mason from the front porch. The door had not closed completely. I still have the license scan, she said, and an old signature from the travel authorization. Mason said something I could not hear. Laura answered more sharply. I know what the witness line says. Another pause. Send it to me. I stood inside the house with my hand resting on the doorknob. My pulse struck hard against my fingers. For one foolish second, I remembered Laura at 9 years old, bringing me a broken jewelry box because she believed her father could repair any lock. I had taught her that a key was a promise. The person holding it entered only with permission. Now my daughter was helping a man manufacture permission I had refused to give. Laura had moved beyond silence. She was offering identification, a copied signature, and her own name beneath a statement she knew might not be true. I did not open the door. I wrote down the time and her exact words, then called Nadia. A private conversation recorded only in my memory was not proof of forgery, but it was enough to tell us Laura was no longer merely following Mason's explanation. Nadia advised me not to confront them while every asset remained protected. "They can still stop," she said. "Do you believe they will? That is no longer a question your money has to answer." Over the next 2 days, Mason behaved as if he were completing routine family paperwork. He emailed me reminders about emergency access. He asked whether I preferred a fixed or variable home equity rate. When I questioned why he needed a rate for document storage, he called it a planning example. Laura sent a separate message telling me not to make the process difficult, because Mason was trying to protect everyone. I read it twice. She did not say he had misunderstood me. She did not ask whether I had agreed. She asked me to become easier to move. I replied only that I was still reading. Behind that performance, he altered the guide he had taken. He removed the visible sample warnings, attached personal information Laura supplied, added an old image of my signature, and presented Laura as a witness. A notary acknowledgement appeared even though no notary had met with me. I did not know every alteration while he was making it. I learned the full list only after the bank preserved the submitted version. Mason knew how to change what a page displayed. He did not understand what the page remembered about where it came from. At 11:42 that night, Mason authenticated through his own Commonwealth Trust profile and uploaded the altered power of attorney. He requested a contact address change, agent access, and information about beginning a home equity application. At 11:43, the bank connected his upload to the warning already attached to my name. Mason believed the delay meant the bank was processing his authority. In reality, it was documenting his attempt. At 8 the next morning, Lena called me from the same conference room where we had created the prevention case. "Nothing moved," she said. "No address changed, no agent was added, no application was opened." I looked across my study at the brass vault key Evelyn had framed for me. What did the system preserve? The submitted file, the account that uploaded it, the time of authentication, and every request that followed. Lena explained that the bank's legal team had preserved the document and placed it under review. Mason could still use his own profile for ordinary messages, but he had never entered my accounts or acquired a single right over my property. He could see the front door while every lock behind it remained closed. "Did he use my credentials?" I asked. "No." He authenticated as himself. Mason had attached a document claiming I trusted him, then identified himself before submitting it. The first bank message told him that additional review was required. 9 minutes later, he asked whether an agent could change the owner's mailing address while a power of attorney was pending. Then he asked whether the same authority would permit a home equity loan. He did not call those requests urgent. He called them hypothetical. Lena's team answered with standard language and directed him back to independent verification with me. By noon, Mason had sent the altered packet to a mortgage lender. The credit freeze stopped the application before the lender could advance it beyond verification. The deed alert ensured that any attempt to record a lien against the house would reach me and Nadia immediately. Nadia contacted the lender's legal department, established that I had authorized nothing, and asked them to preserve what Mason had submitted. He also sent the document to my brokerage. The brokerage called the telephone number it had held for 11 years, mine. "Mr. Hale," the representative said, "a person identifying himself as your financial agent has requested access to account information and transfer procedures. Did he provide a valid authorization? The document is under review." Then my answer is no. She read the restriction Nadia had placed and confirmed that no information had been disclosed. 3 institutions had received the same claim of authority and stopped at the question Mason hoped technology would eliminate. Did the owner actually agree? Caleb found the answer Mason had given his lender. Before uploading the altered packet, Mason described the proposed loan as temporary family liquidity that would stabilize his company. There was no commitment or repayment schedule from me. The lender stopped at verification, but its record preserved what Mason had represented. That afternoon, Nadia and I reviewed the preserved bank copy beside the standard digital template in her client file. The visible differences were obvious. The warnings were gone. My identification had been attached. An old signature appeared where no signature had existed. Laura's name sat beneath a statement declaring that she had watched me sign voluntarily. The electronic signing certificate attached to Laura's witness statement recorded her authentication at 2:15 in the afternoon. Her declaration said I had signed in her presence during that same electronic session. At that moment, I had been sitting across from Dr. Wu in Nadia's office, explaining the consequences of a financial power of attorney and why I did not want Laura or Mason to hold one. Dr. Wu's appointment record placed me there. Nadia had been present for part of the meeting. The building's visitor record confirmed my arrival and departure. Laura had certified her presence in a signing session that occurred while I was somewhere else. She may say the time was entered incorrectly, I said. Nadia shook her head. Laura did not enter it, Nadia said. The platform recorded when she authenticated. The statement tied her witness certification to that session. I traced the edge of Nadia's standard template without touching the altered copy. When she was 12, she confessed to breaking Evelyn's lamp before we even knew it was broken. People do not become dishonest all at once, Nadia said. They make one exception, then protect it with another. The false notary acknowledgement created the next break. The name belonged to a real notary named Elaine Porter. Contacted through the state registry, she confirmed through counsel that she had never met me, witnessed my signature, or performed a remote notarization for Laura or Mason. Her commission information had been copied into a form she did not create. How Mason obtained it belonged to investigators. For the bank, the essential fact was that the claimed notarial act had never occurred. The packet supplied another layer. Mason had removed the warnings a person could see, but the standard template identifier and version still matched the guide stored in Nadia's client file. He had altered the face of the document and preserved its ancestry. He knows how to edit a file. Lena said when she joined us, "He does not understand evidence management." "That is what people say when they have only seen the front of a system," I replied. Lena did not smile. None of us found pleasure in the fact that the trail led through my daughter. The audit showed Mason authenticated through his own profile before uploading the file. His requests for address control and loan information followed from that profile. The system did not know Mason's heart, it knew his sequence. While that sequence was being preserved, Mason called me twice a day. On the first call, he said the bank was slow because older institutions were afraid of digital change. On the second, he blamed compliance employees who did not understand modern families. On the third, he said, my failure to answer verification calls might delay the protection he was arranging for Sophie. What protection, I asked. Keeping the family stable. Her tuition, her future. All of it depends on us getting through the next few months. I looked at the financing projection Caleb had preserved: bridge lender, investor settlement, payroll, business reserves. Sophie's name appeared nowhere. Then perhaps we should review the plan together, I said. His answer came too quickly. Once the authority is recognized, there will be time for that. He wanted trust before explanation and control before consent. I asked whether the delays worried him. Not at all, he said. A pending review usually means the system accepted the upload. Mason heard silence and imagined approval. He saw delay and imagined progress. Every closed door became proof that someone was about to open it. Laura was less certain. She came to my house on Sunday carrying a casserole I had not requested. She kept looking toward the study while telling me the children were busy. "Has anyone from the bank called?" she asked. "Banks call me often." "About the documents Mason organized." "Why would they call about a training packet?" The serving spoon stopped above my plate. "I thought Mason had paperwork that let him help." "Did you watch me give him more?" For a moment, neither of us moved. Then she placed the spoon down and said Mason handled the technical details. I could have confronted her with the witness statement. Instead, I gave her the final opportunity ignorance could still explain. "Laura, if anyone has submitted a document claiming I signed it, tell me now." She looked directly at me. "No one is trying to hurt you, Dad." It was not an answer, but it ended the question of whether she would choose one. I remained at the table after she left. The casserole cooled between two untouched plates. I had spent days preparing for Mason to choose money over law. I had not prepared for the quiet precision with which my daughter would choose his story over my question. Anger would have been easier. Anger gives the body somewhere to send its strength. Grief leaves it sitting in an empty chair. I carried both plates to the sink, washed them, and called Nadia. After she left, Nadia returned with the final version of my estate plan. The house, cabin, investments, and remaining assets would stay under my control for the rest of my life. If I became unable to act, a licensed professional fiduciary would manage them under strict written duties. Laura and Mason held no financial power of attorney and no position as successor trustee. After my death, the estate would fund separate trusts for Sophie and her younger brother. Their parents could not borrow from those trusts direct investments or use distributions to settle personal debts. Education, housing, health, and carefully defined support would be handled by an independent trustee. A second fund established the Evelyn Hale Scholarship in Cybersecurity. Evelyn had believed that a lock was care made visible. The scholarship would help young people learn to build locks that protected strangers they might never meet. Laura remained a conditional beneficiary. I had not erased my daughter from my life with a pen, but she would never again be in a position where loving me could be confused with controlling what I owned. Removing her name from the successor trustee page took less than a minute. Accepting what that removal meant took longer. Laura had once been the person Evelyn and I trusted to protect the family if neither of us could. I was not rewriting that history. I was refusing to let history substitute for present evidence. I signed the plan in Nadia's office with independent witnesses. Dr. Wu's capacity evaluation was attached to the record, not because caution was confusion, but because Mason and Laura had already prepared to claim it was Sophie knew none of this. She came by that evening with a programming assignment and asked why software sometimes required two people to approve one change. Because a good system allows for the possibility that one trusted person may be wrong, I said, or dishonest, sometimes, but mostly human. She returned to her code, complained about a missing bracket, ate 2 of Evelyn's frozen cinnamon rolls, and left with my old book on access controls beneath her arm. Her affection did not need to become evidence. 2 days later, Lena reminded me that Commonwealth Trust's Secure Futures dinner was approaching. The bank intended to recognize the anniversary of its security program, announce Evelyn's scholarship, and honor the early architects of the system. Mason already knew I would be recognized. For weeks, he had been telling Laura the dinner would place him in a room with bank executives and potential clients. I called him. The bank asked whether a family member would say a few words about technology across generations, I said. He became silent, then careful. I would be honored. You have helped me understand a great deal about how you use it. He heard praise because praise was what he expected. By evening, he had sent the event coordinator a biography describing himself as the person helping me modernize my financial life. He drafted a speech about guiding an old security professional into the digital age. He even asked whether the bank could introduce him as my family financial agent. The coordinator told him titles would be confirmed at the event. Nadia reserved a private conference room for after the scheduled remarks. There she secured the standard template, Mason's submission, Laura's statement, the notary response, and Caleb's projection. Lena retained the audit record under the bank's legal hold. The ballroom would hear only what was necessary to correct Mason's public claim. The detailed evidence belonged upstairs with counsel and investigators. That separation mattered. The bank owed me protection, not a public prosecution of my family. If Mason used the stage to claim authority over my finances, I would correct him. Proving how he manufactured that claim would happen behind a closed door. On the night of the dinner, I fastened the brass vault key beneath the photograph of Evelyn at the scholarship display. Sophie arrived in a blue dress, proud of her father's invitation and unaware of what he had done. Laura entered beside her, pale beneath the ballroom lights. Then, Mason walked through the doors with a folded speech in his pocket. My son-in-law entered Commonwealth Trust expecting to be introduced as the man managing my future. 1 floor above the ballroom, a locked conference room, held the record of how he had tried to take it. Mason walked onto the stage, expecting a bank full of security professionals to applaud the way he had deceived an old man. For the first minute, they did. He stood beneath the Commonwealth Trust emblem and thanked the executives, employees, and former colleagues who had gathered for the Secure Futures dinner. Then he turned toward me with the warm expression he normally reserved for investors. Victor taught an earlier generation how to protect banks, he said. I have had the privilege of helping him adapt those lessons to the digital world. Polite applause moved through the ballroom. Mason smiled. He still prints important emails. He still believes a paper statement is more honest than an app. But progress works best when younger people help the generation before them let go. Several guests laughed gently. Mason mistook kindness for agreement. Sophie looked toward me, embarrassed on my behalf. Laura did not look up at all. Mason finished by saying families had a duty to prepare before age made financial decisions difficult. He never used the words power of attorney. He did not need to. He believed the title family financial agent would be announced after his speech. Instead, Lena introduced me by the title. Mason had never understood. Victor Hale, founding Chief Security Systems Architect of Commonwealth Trust. The screen displayed a photograph of me beside the engineers, lawyers, fraud analysts, and branch employees who had built the bank's early security framework. Mason had seen it in my study and assumed I was the man who kept their servers running. I carried the framed brass key to the lectern. Mason is right about one thing, I said. I print important documents. His smile returned. I do it because I spent 36 years designing systems for people who believed changing what appeared on a screen changed what had happened. The smile disappeared. I explained that secure institutions confirmed authority beyond the page. A principal had to consent independently. A notary had to be verified. Requests following a new document had to make sense. A secure system does not trust its designer either, I said. It trusts evidence. Then I corrected the claim Mason had made publicly. I have not appointed Mason as my financial agent. I have never signed a power of attorney granting him control of my home, investments, or accounts. Lena joined me only long enough to confirm what the bank could properly disclose. No authority was approved, she said. No access was granted, and no money moved. Nothing else appeared on the ballroom screen. No client record, no witness statement, no audit log. I announced the Evelyn Hale Scholarship in Cybersecurity and placed the brass key beside my wife's photograph. The applause that followed belonged to Evelyn and the purpose of that scholarship. Not to the dispute in my family. Mason stood before I left the lectern. That is not what happened. Victor asked me to organize his estate. The bank's general counsel stepped forward. Mr. Reed, any document you submitted will be discussed privately with the appropriate parties. Mason looked around the ballroom, searching for a room in which confidence could still become proof. Then he followed counsel toward the elevators. Laura walked behind him. Two investigators entered separately after the doors closed. Upstairs, the private conference room held no audience. Sophie remained with Nadia's assistant in another office. Around the table sat Mason, Laura, Nadia, bank counsel, two investigators, and me. I placed Nadia's standard family digital records training packet beside Mason's submission. The first carried the same warning on every authority page. Not valid. No authority granted. The second had lost the warnings but still came from that standard template. You left paperwork where I could find it, Mason said. I told you the guide was not part of the archive. You took it and converted it into a claim of authority. You set me up. I protected my accounts. You supplied the fraud. Nadia confirmed that the packet contained no valid signature, witness certification, or notarization when it left her office. Then she returned the discussion to me. I opened Laura's witness statement. The electronic certificate recorded your approval at 2:15. You declared that I signed in your presence during that session. At the time, I was completing an independent capacity evaluation in Nadia's office. I placed the notary's response beside it. The notary also confirmed that she never met me or notarized my signature. Laura's hands folded around each other. Mason told me that part was valid. You still certified an event you never witnessed. Mason proposed the lie, but your name helped carry it. Mason pushed his chair back. You manipulated us. You pretended not to understand. I understood every word. Correcting your assumption was less important than stopping you from speaking for me. I placed his financing projection at the center of the table. Hale property liquidity. $650,000 available. The date preceded the packet and every request for my consent. Below my house were the bridge lender, investor settlement, payroll, and business reserves. That was only a scenario, Mason said. You presented it to your lender as committed family capital. We were protecting Sophie's future. Her name appears nowhere in your plan. You used your daughter's future to explain why you needed to steal mine. Lena confirmed one final fact. Mason had authenticated through his own profile before uploading the altered document. His address request and loan inquiry followed from that profile. The audit did not need to guess who pressed the button. Mason had identified himself. You made me look like a criminal, he said. No. The audit trail described what you did. You recognized yourself. He argued that technology companies moved faster than banks and that older systems punished innovation. I let him finish. You mistook my refusal to trust every screen for an inability to understand the system behind it. You knew how to upload a document. You never learned that the system remembers who uploaded the lie. Nadia then summarized the boundaries in my new estate plan. I retained control of every asset. A professional fiduciary would act if I became unable. Laura and Mason held no authority or management role. After my death, independent trusts would protect the grandchildren, and neither parent could control them. You are cutting us out of our children's future, Laura said. No, I am separating their future from your debt. I thought we would repay everything. You treat it eventually like a password. You believed it could unlock property before permission. Bank counsel confirmed that the matter had been referred to the appropriate authorities. The investigators asked Mason and Laura to remain for separate interviews. Before I left, Mason stopped beside me. You do not understand what it takes to keep a technology company alive. I understand that systems fail when the people running them believe rules apply only to slower people. Then the conference room door closed between us. I found Sophie in Nadia's office with the folded program pressed between her hands. She had been crying, but the first thing she said was not about the trust. Grandpa, why did you let Dad think you did not understand? Correcting his insult was less important than protecting my accounts. I secured them while he still believed I would not notice. Did you want him to take the packet? No. I told him to leave it on my desk. He took it anyway, then chose what to make of it. She looked toward the conference room door. Did he really say he was doing it for me? Yes. I never asked him to. I know. Her voice broke. Does the trust mean you think Mom will steal from us too? I sat beside her. It means neither child should have to decide whether saving a parent is worth surrendering a future. An independent trustee makes that decision unnecessary. Did you give us the money because we believed you? No, you knew nothing. That is why this can never become payment for taking my side. She leaned against my shoulder the way she had when she was small enough to fall asleep during Evelyn's stories. I did not tell her everything would return to normal. Normal was the story Mason and Laura had used while they moved toward my house. I told her only what I could promise. Your father's choices are not your debt. The consequences arrived without music. The mortgage lender cancelled the application. The brokerage rejected the document. The deed alert remained active. Commonwealth Trust permanently denied Mason access to any relationship connected with me. Because every institution had stopped before approval, my house was never mortgaged, my investments never moved, and not $1 funded his company. Reed Property Intelligence failed 4 months later. The bridge lender pursued its claim. Investors produced messages and projections that Caleb had never seen. Mason faced charges involving forgery, attempted financial exploitation, and misuse of identity information. Some issues ended in negotiated resolutions. Others remained with the court. I did not need a dramatic sentence to know the business he tried to save with my life had collapsed under the weight of its own records. Laura cooperated with investigators. Her attorney argued that Mason had pressured her and concealed the full plan. That was partly true. It was not the whole truth. Mason may have proposed the fraud, but Laura supplied the pieces he could not have obtained without her. My identification, an old signature, and a false witness statement. Desperation explained the road she entered. It did not erase the distance she chose to travel. Mason and Laura separated before the year ended. Sophie moved into a university residence and began counseling. Her brother stayed mostly with Laura and spent weekends with me when he wished. I never asked either child to choose a side. I never showed them the evidence to make myself look righteous. The trust was not a reward for believing me. It was protection from being used again. Commonwealth Trust incorporated the case into staff training without identifying the family. Employees studied why an impressive document could not replace independent consent, why urgency should increase verification, and why age-based assumptions created openings for exploitation. The first Evelyn Hale scholarship went to a nursing assistant who had returned to school after watching patients lose savings to impersonation scams. At the ceremony, her mother touched Evelyn's photograph and thanked me. I told her the scholarship belonged to the woman whose sentence had guided me when love and access became difficult to separate. 8 months after the dinner, Laura came to my house alone. She looked older. Not because time had accelerated, but excuses no longer carried part of her weight. Dad, I never wanted Mason to take everything. You gave him the documents because you wanted him to take enough. I thought the company would recover. We would have repaid you. Repayment is a plan made before borrowing. You were planning it after forgery. She lowered her head. I am sorry. For once, she did not attach a reason. I believed she was sorry. Believing that did not restore authority. Laura told me she had begun therapy and wanted to rebuild our relationship. I said I wanted that too. Do you think you will ever trust me with a key to this house again? She asked. I did not answer immediately. For once, Laura waited instead of speaking for me. If we rebuild something that does not depend on money, perhaps. I am not asking about the estate. Good. A key to my house and control of my future are not the same permission. Forgiveness may let you back into my life. It does not return the permissions you misused. The boundaries remained plain. Continue therapy. Cooperate fully. Never call the children's trust a punishment or make them responsible for saving either parent, she agreed. I offered her a path, not an unlocked door. Several months later, Sophie visited after her first university course in cybersecurity. She placed her backpack on the study floor and stopped before the framed brass key. "Did that key ever open the bank vault?" she asked. "No." "Then why did Grandma keep it?" I lifted the frame and showed her the inscription in Evelyn's handwriting. "A lock is not distrust. It is care made visible." "Because the strongest security is not the thing that keeps everyone out," I said. "It is the thing that makes sure the right person is still allowed in." Sophie studied the words. "Is that why you still use paper statements?" "Technology is excellent at remembering what happened. Paper is excellent at reminding people to look." She smiled and asked if she could borrow another one of my old books. Mason believed being modern meant moving faster than anyone could question him. I had spent my life building systems that asked the question before the money moved. He called me old-fashioned because I still read every page. By the time he finished clicking through mine, the system had already read him. "If your daughter signed a lie giving someone else control of your home, could you forgive her without ever trusting her with access again?"